Hey everyone! If you're a law student staring at that family law syllabus, you know it can feel like a total beast. But honestly, it doesn't have to be. We're about to break it all down into a super simple framework that's actually easy to remember. This is going to be your ultimate guide to acing that exam. Let's dive in.
You know, when you really think about it, family law isn't just about dusty old books and complicated cases. It's the legal blueprint for our most important relationships. It shapes everything, from how we get married, to our rights and responsibilities, and even what happens when things fall apart. It's really the story of our lives, just told through a legal lens. So here's our game plan. We're going to follow the logical life cycle of a family. First, we'll look at the contract of marriage. Then, what happens inside the family, rights, duties, all that. After that, we'll get into property, gifts, and wills. Then, the tough stuff, the end of a marriage. And finally, we'll zoom out and look at the big picture debate. Should we have one law for everyone?
All right, let's start at the very beginning. Every personal law in India has its own way of forming a family. You know, under Hindu law, marriage is a sacrament, a sacred bond. But today, we're going to kick things off with a really key concept from Muslim law, where the Nikah is viewed very differently, as a civil contract.
Okay, the one thing you absolutely have to remember about Nikah is this dual nature. Yeah, it's a sacred bond, for sure. But legally speaking, it's a civil contract. And just like any other contract, it needs those essential elements. You need an offer, which is ijab, and acceptance, which is Qubul, and this is so important, the free, willing consent of both people.
And boom, here's the proof. This quote is a golden nugget for your exams. It's from way back in 1886, the case of Abdul Kadir versus Salima, and it laid it out plain and simple. Marriage under Muslim law is a civil contract. This case has been the foundation for legal thinking on this ever since.
So, not all marriages are created equal in the eyes of the law. There are basically three categories you need to know. First, you have Sahih. That's a perfectly valid, good-to-go marriage. Then there's Fasid, which means irregular. Think of it like a software bug that can be patched. Maybe you are missing witnesses, you can fix it, and it becomes valid. But Batil is totally void. It's got a fatal, unfixable flaw, like marrying someone you're prohibited from marrying.
Okay, so the marriage contract is signed, sealed, and delivered. What's next? Well, a whole bunch of legal rights and duties just kicked in for everyone involved. Let's unpack what life inside the family actually looks like according to the law.
Now, a massive concept here is Mahr, or dower. And listen up, because this is crucial. Mahr is not a gift, it's not dowry, it is a legally binding debt the husband owes the wife. It's a sign of respect, and it's meant to give her financial security. The Hamira Bibi case really cemented this as an absolute enforceable right for the wife. And Mahr isn't just one thing. It comes in two main flavors. You've got prompt Mahr, which the wife can ask for literally any time after the marriage. And then you have deferred Mahr. That one only becomes payable when the marriage ends, either by divorce or, death. This distinction is exactly the kind of detail they love to put in problem-based questions on exams, so make sure you know it.
Okay, what about day-to-day living expenses? That's maintenance or nafaka. The rules are pretty clear. The husband provides for the wife. The father provides for the kids. And then, in this really amazing reciprocal duty, the children have to provide for their parents if they're elderly or can't support themselves. Now, this is where the legendary Shah Bano case comes in. It was a game changer because it said a divorced Muslim woman could claim maintenance under a secular law, Section 125 of the Criminal Procedure Code. It sparked a massive national debate.
This leads us right into the money side of things, property. How does the law handle assets? How are they managed during someone's lifetime? And how are they passed down? We're going to cover the big three: gifts, wills, and inheritance.
Making a valid gift, or hiba, seems simple, but you have to hit all three of these points. It's a non-negotiable three-step formula. First, a clear declaration, I am giving this to you. Second, the other person has to accept it. And third, this is the one people forget, the actual physical delivery of possession has to happen. If you don't hand it over, it's not a valid gift in the eyes of the law. Simple as that.
Now, when we talk about wills, or wasiyat, there's one magic number you have to remember for your exam. It's the 1/3 rule. A person can write a will and give away up to 1/3 of their property to anyone they want, a friend, a charity, whoever. But if they want to give away more than that 1/3, they need to get permission from all their legal heirs. So just burn this into your brain. Will equals 1/3 free.
Succession in Muslim law has a really clear pecking order. First up are the sharers. These are the people who get fixed, specific fractions of the property laid out right in the Quran. After they get their slice of the pie, whatever's left over goes to the next group, the residuaries, and only if there's no one in those first two groups do the distant kindred get anything. It's a very clear top-down system.
All right, here's a pro tip for you. This is for those tricky inheritance math problems. What happens if you add up all the sharers' fractions and they total more than 1? You can't give away more property than you have, right? That's where the doctrine of all comes in. Everybody's share gets proportionally shrunk down until it all fits, and the opposite is rad. If the shares only add up to, say, 0.75, they get proportionally bumped up so that the entire estate is distributed.
And now we come to a tough but really important topic, how marriages end. The law doesn't just let things fall apart, it has specific procedures and remedies for when a marriage breaks down.
You know, the law around divorce has been anything but static. This timeline shows two absolutely monumental shifts. We already talked about Shabano in '85, which blew the doors open on the whole personal law debate. Then, fast forward more than 30 years to 2017, and the Supreme Court in Shariat did something huge. It declared the practice of instant triple talaq unconstitutional. A massive, massive change. Okay, shifting gears a bit to Christian law under the Indian Divorce Act. Here is a total lifesaver for your exams. Just remember the mnemonic, DJRNAC. That's it. It stands for the 6 big remedies: divorce, judicial separation, restitution of conjugal rights, nullity, alimony, and custody. And for bonus points, remember that the specific grounds for getting a divorce are all laid out in Section 10 of that act.
And finally, let's pull the camera all the way back. We've been talking about specific personal laws for different communities. But what about the bigger question? What about one single family law for all Indians? This brings us straight into the heart of the Uniform Civil Code debate.
So this whole idea of a single secular law is not just some abstract theory. We've actually had a version of it for decades. It's called the Special Marriage Act. This law is so important because it lets any two Indian citizens get married, and it doesn't matter what their religion is. It's a civil marriage that exists completely outside the world of personal laws. It's a real-world example of how a uniform law can work.
And this idea, this push for one law for everyone, comes from the highest law of the land, our Constitution. Article 44 is what's called a directive principle. It basically says the government should try to create a uniform civil code for all citizens across the entire country. It was an ambition, a goal, set by the people who wrote the Constitution.
And it's not just an old idea collecting dust. The Supreme Court has brought it up again and again. In that very same Shabano case, the court basically said, hey, it's a shame that Article 44 is still just an idea on paper. They argued that a common civil code would actually help bring the country together. This just shows you how long this conversation has been going on at the highest levels.
So to wrap this all up and get you ready for that exam, here it is, your super recall formula. The entire syllabus is just a 6-word story: faith, family, property, inheritance, divorce, and equality. That progression covers every single unit we talked about. And here's one final killer tip. For every concept, link it to its section number. Make flashcards. Section 10, Indian Divorce Act, grounds for divorce. Section 125, CRPC, maintenance. You do that and you will absolutely lock this stuff in your memory.
Which leaves us with the big, lingering question. For a country like India, which is so incredibly diverse, with so many different cultures and faiths, is a single, uniform family law really the best way to achieve justice and equality for everyone? That right there is the central question that's going to shape the future of family law in this country.